Right, so I'm quite sure this is correct and legit, right? So, according to the Act that I looked at the other day briefly from Scotland, so you had the local 100, right? And you've actually got you have six aldermen, which are like jurors. So they're kind of like jurors, but they're called aldermen. And then you're meant to have the justices of the peace, right? And you might have a recorder as well. This is like in Sam Sterling, the Mayor of London at the Old Bailey. But they also actually have a jury as well, but that's in the town, right? And that's the Assize. Now, this is like effectively the court, right, of the local area. And every area in Scotland, for example, had one of these, right? And also you've got your sheriff as well, who deals with the law for crimes. Because you've got a little form you fill in, like a little affidavit. So they would hear the crimes or offences and also civil disputes, but also civil request issues with the local council, right? But you've got there's some things that are like consents, building, planning. Then there's like roads and highways, allocating money and finances and so forth, right? Now people bring their cases here, but these 6 councillors are elected like our councillors, but they're kind of they're sort of like jurors, right? And then you've got the sheriff. And then you've got really the justices are kind of like the justices are like the cabinet on the council, right, with the jury at the side. But the jury actually are the councillors, right? And then you've got the King's justices coming round at the Assizes, come round. Quarter sessions are 4 times a year, and the Assize is like twice a year. They're meant to be the circuit judges, the kings. They're meant to be the king's justices, and they go on the circuit. And in England, they finish up at Westminster, and they've got the Tower of London, right? But you've got all these high courts in London as well, like Special Chancery, Westminster Hall, King's Bench, Court of High Commission. They had various different courts, higher courts, but this is so these now are the same as the Crown Court and the High Court, although the Crown Court doesn't deal with civil matters. So this is like the difference between the County Court and the High Court, or the County Court and the Magistrates Court, and the Crown Court. Now this one, because this comes round on a circuit, this one has a jury, and whenever this comes round, right, the sheriff arranges for 12 jurors from the local public chosen at random there, right? And these are going to be with the King's justices, right? With a jury of the public selected at random, right? If it's in the 100, not a serious crime, right? You've got these elected ones who serve full time, okay? But when it's the higher court and the King's judges coming round, you get these randomly chosen people, right? Now, what's happened is also, if you have a matter in this council, right, you can appeal, but you don't have to appeal to this Assizes. You can actually appeal to the council itself, and they have a committee of 3 to hear it. Now, I don't know whether it's your 3 justices without these, so like having it again without a jury, or whether it's any 3 of the councillors have a committee, right? But you can actually appeal it to a committee of 3 if you're not happy with the decision. But then that's it, they're saying. But this is only the same level as a magistrate. That's kind of like the same as a magistrate's court hearing a matter again, but not having like 1 justice, having like it to be to 3. And actually, that's true, because I've actually read in the Magistrates Court Act, if you want a matter to be set aside, it's looked at by 1 justice, and if he's not going to set it aside, then he has to go to 3 of them, right, to decide, which is kind of like a committee of 3. So really, when I looked at the Magistrates Court Act, 1980, I think it is, they've actually got something like that in there, actually. If one of them doesn't approve it, it goes to 3, right? So there's something like that still. Okay, that's important. Now, what actually happened? Well, around 1960s, 1970s, they scrapped this quarter sessions and assizes, which is 4 times a year and twice a year, same thing, right? And usually it's lords, barons, earls, high judges, you know, could be knights though, who sit this. And then they established it. They split it, so the criminal side was the Crown Court, and then they hold that all the time now. And then the civil went into the County Court and the High Court. But you might say, well, you've got County Court, which is equivalent to Magistrates Court, and then you've got the High County Court, which is meant to be similar to the Crown Court, right, in London. Now, the thing is, right, what's happened to the council? Well, what they actually had was that if you've got a matter with the council, right, or if the council's got a matter, there were some things in the council where you could actually ask for it to be heard with here, right, and ask for a random jury, not the permanently elected ones. This is higher, remember, right? You could do it a higher, you could refer it higher. But there's also the option to petition Parliament still, and I get the Lord Advocate as well, right, which is similar to the Attorney General, right? But you opt for that instead of having it heard here. You can opt instead to have it heard at the Assizes, which is like, or Parliament, right? Okay? Instead of having it heard here. Because you've got your right to petition. And in this council, you've always got a slot. They've got an allotment of time they must allocate to hear petitions, right, about any matter that's been heard. Well, in the petition, you can say, right, well, I want it to go to the Parliament or to the Assizes, right, or quarter sessions instead. Now, what act could you use for that? Well, you've got your 1661 Tumultuous Petitioning Act. In fact, if you had over 20 people, you had to ask permission if you wanted to go to Parliament. Now, where would you get permission from? Well, 3 justices. The council, the heads of the council were justices of the peace. They were judges, so they were authorised to sign. Those 3 there in the council were authorised to sign the petition to give you consent to take it to Parliament, right? Or you can go to the Assizes, but there wasn't. The Assizes can also give you the Assizes have got judges to give consent to Parliament, but if it's under 20 people, you didn't need their permission. You had the right to do it anyway, so you could still tell them, right, we're petitioning Parliament instead, or the Assizes, but you don't need them to sign it off. If it's under 20 people, only if there's a very large number of people that need signing off, right? That was a 1661 Act. Now that's repealed. You don't need permission or consent, but there's still a right to petition Parliament or the Assizes over any matter in there, really, because it's a basic fundamental right. Or actually have a random jury, not these guys, because remember the random jury is in front of the Assizes is higher than the council, right? Okay. And also, if you had it heard by these 6 councillors and you were not happy with the outcome, right, you could have it before a committee of 3. But after that, that was it. They could not hear it again after that. Now, that's kind of similar to the Magistrates' Court, but the Magistrates' Court are claiming that they can't hear it again at all anyway, but that's a lie, and I think the council lying. But this is the thing. This is criminal. This is criminal, and all the matters of the town, civil requests, and tort cases between 2 arguing parties. Okay? It's everything. Right? Now, with most of the matters, you could appeal it to the Assizes anyway if you weren't happy with the decision. Okay? Because you've got a legal right to do that. Or Parliament. But if you go to have them to hear it again, apparently you can't go there. But there's something to do with, they're trying to make out that if you do have it heard by this lower level, apparently they're trying to say that you can have it appealed there, but then if you have it appealed there, you can't go to a higher court. But if you decide not to have it heard there, you can have it heard at the Assizes or by Parliament instead. But I think there's always a right for Parliament, but this is the model anyway, right? And this actually fits with the 1661 Act perfectly, and the right to petition and Magna Carta. Now, what happened? Well, as the urban area grew and there's more and more people everywhere, there was a lot more things to do than just this, and you've got more areas. So you're actually getting more permanent councillors you need, right? You got more permanent councillors because you've got all these areas, you've got all these electoral areas rather than just one big county with not that many people and a few farmers here and there, right? So you've got one of these councillors for each ward, and you might have 10, 20, 30, 40, 50 wards. So you've got all these councillors here who are all elected, but it's still at this level. They're not the Assizes level or Parliament. And also, because there's a lot more civil request business to do in this council, what they've done is they've put a separate court right here specifically to hear criminal matters, and they appoint 3, which is like your committee of 3, but they've created 3 justices positions who are committed and given a commission to hear criminal matters. And you might have a district judge. And then the county court, where you've got a district judge, and they hear tort cases between 2 parties, right? Because this is very, very busy doing all the civil requests for like planning consents and maintaining the roads and so forth. But this is all at the same level. It's just that they've created other courts to do the business because they're too busy doing the business. But you've still got this higher assizes coming round with a jury, right? Now, what I think, if you get convicted at the magistrates' court, you can appeal to the assizes. And if you're not happy with that, you can appeal to the High Court. And then you still always had, right up till 2005, you can appeal to the House of Lords. Okay, petition the Lords. That's after. I think you always had this option to do it before you've got it heard here anyway. Instead of having it heard there, which is like your right to petition the King or either Houses of Parliament, even first, beforehand, or even if you've got a case that you want to bring about the whole nation or country to Parliament, and it's none of these jurisdictions' business, which is why you can't be convicted, prosecuted, arrested or imprisoned by them. It's not their case, it's Parliament jurisdiction in case, right? Now, currently, they're saying that the county court, which is the go-to court or the magistrates' court for the council if they want anything enforced or done, because they're busy putting orders through. And now they've got a rule where justices can't be members of the council, they've already got to be separate. You can have like this judicial review of if a council does something wrong. If the council breaks the law or doesn't follow a rule or procedure, you can get that looked at by the assizes. That's because the assizes have got jurisdiction over these judges and they can actually prosecute these judges if they do wrong, right? But they're saying that if a council makes a decision, there's no appeal, which is false. That's false. In fact, you don't even have to have it heard by the council, it turns out. You can actually have it heard by the assize level, the Crown Court level, the High Court level, instead of a local council, right? Or Parliament. I tried to petition Parliament and they said they wouldn't list it on the petitions website, but you can have it instead. But I think you can do it after, instead of having it by this committee of three, which is effectively just like three magistrates, right? Which effectively could be the county court. It could be the county court, which means that you really have got a right to appeal to the county court if you're not happy with the council decision. Because if you've got three magistrates in the county court, then it's just like the council having a committee of three. But I'm not bothered if they want to appoint three councillors to it or just have the cabinet on the council. But this petition point in here, now what Parliament are saying is if you get the petition, the Secretary of State will give a local referendum, which is that everyone will vote on it. But that's, if not better, than having your assizes. But you can have actually committees in Parliament make a judgment on it, just like you'd have a committee here. But in Parliament, there are different resolutions you can have by Parliament. But Parliament in modern law, in the Local Government Acts and so forth, they're saying that if you're going to petition and get a lot of signatures, they're going to give you a local referendum, which is just like a consultation that the council are doing anyway. The council are running consultations, but then they're saying they're not going to act on it, which is a waste of money, really, to say that you're going to all that trouble of asking people, but they don't have to do what they say. Saying that if you petition Parliament and they give you a local referendum, then they have to do what they say. Or if you wanted to go to the High Court and have a jury, and then that jury will decide who are completely and totally picked at random, independent, and not even these councillors. And you know you're getting a fair decision then because they're not from the area and they're not getting influence or bias from political parties or investors, contractors, or this strategic planning that's going on, or their history or past in the area or council, which can be biased. It would be fresh. And I actually think that this still is legal. I think it's legal. I think it's legal because when you have go into that council and they've got to allocate 5 minutes or 10 minutes to hear petitions for whatever matter's being heard, right? We want to build a housing estate, right? Well, here's a petition, we want it heard at the Assizes. Or here's a petition. Doesn't say what you can and can't petition for in the council rules. They've got all their rules and procedures for them if you have it heard there. All these rules and procedures they've got if you want them to hear it. Where's the USB socket? Plug in what you want. Here's a petition. I have got the creative freedom of right of subject. Right, I want Parliament to hear it. The Secretary of State says, right, well, we'll give you a local referendum. Or you might put it to a committee in Parliament, petitions committee or whatever, or set up a committee or whatever. Or you can say, oh, for the petition, right, we want it heard at the Assizes with a jury, with the King's Judge, right? That's something you can ask for, petition for. If you're in a magistrate's court, you can say, I want it heard at the Crown Court with a jury. And they'll say, okay, right? Now, some offences aren't an indictment. Depends how serious it is, but if it's a redevelopment of the Old Town Centre, it's not just like someone tarmacking the drive, is it? This, I'm telling you, this is legit. You won't find it in the council rules because when you write a petition, you are writing it. And it says in some of these local government acts, some of them, there are quite a lot of them, it's saying that when you write a petition out, it's like putting a bill before Parliament, like writing a new law out. This is a brand new law that I want Parliament to put through. And when it gets approved, you're asking for anything on this. You could even say, right, I want an award. You're making up your own like thing from scratch, and you're saying this is what we want. So you're saying, right, we want award referendum with 3,000 people, run at 2 polling stations, and we want it in September, and we want it run over 3 days. That's what you're asking for. They can approve whatever they want. Right? You've got creative license. And what's what the council don't understand? They're looking through the legislation and they're looking through their rules and procedure. It says 5 minute slot for petitions of what? Of a blank sheet of paper, what you are proposing and requesting. Ban smoking, right? Give me a ward referendum with 3,000 people, and I want a week to collect the signatures. Sign it there, councillor, right? Sign on the dotted line, right? I want to petition Parliament. Sign off 3 justices there, 3 councillors, sign there, right? I want it heard at the Assizes with a jury, right? Town Centre redevelopment. We want it heard at the Assizes with a jury. This is legit.